The Supreme Court's 8-1 emergency decision just sent shockwaves through every state house drafting pro-gun bills. Missouri's Second Amendment Preservation Act, built to slam the brakes on federal gun control raids, now hangs by a single Supreme Court thread. How does one ruling threaten to redraw the battle lines between Washington power brokers and hometown sheriffs sworn to defend your right to keep and bear arms? In this video, we'll talk about the high-stakes chess match unfolding between Missouri, the Justice Department, and a Supreme Court that could either supercharge the 10th Amendment or tie it to a courthouse post. We'll look at how a civil penalty clause turned a feel-good resolution into a legal battering ram, why the lone dissent came from Justice Clarence Thomas, and what the Trump-era Solicitor General's tactical dance means for sanctuary bills already queued in a dozen capitals. Stick around for the timeline that ends on June 10th, when a single DOJ brief may decide if states can refuse to bankroll federal gun squads, and get a first look at two sleeper cases that could make this the biggest Second Amendment term since Bruin. Buckle up. The next 15 minutes may change how your sheriff answers the ATF's call. In 2021, the Missouri General Assembly passed the Second Amendment Preservation Act, or SAPA, after months of pressure from sheriffs, gun rights volunteers, and county commissions who are all sick and tired of watching Washington rewrite firearm rules every election cycle. The bill, filed as House Bill 85, opens with an unequivocal declaration: any federal statute, regulation, executive order, or treaty provision that infringes the right to keep and bear arms is invalid in the Show-Me state. It names likely offenders, future taxes on guns, forced registries, blanket bans on common sporting rifles, and red flag confiscation orders. Symbolic resolutions of this kind have floated around for years, but SAPA adds teeth by forbidding every state or local official from assisting federal agents in enforcing the disfavored measures. If an agency ignores the command, any affected Missourian may sue for $50,000 per violation, payable from that agency's budget, an amount large enough to grab a police chief's attention yet still survivable for a small department. SAPA's drafters rested their case on a bedrock principle. The 10th Amendment prevents Washington from commandeering state resources, so Missouri will not volunteer its deputies, radios, or cruisers to prop up gun control schemes that Congress lacks the horsepower to enforce alone. Federal agents can still arrest a felon with a rifle, but they must bring their own handcuffs and write their own reports. States have long used a similar approach to avoid participating in immigration raids. SAPA merely applies the same logic to firearms. What makes the statute different is the personal liability clause. If a county detective forwards ballistic data from a 30-round magazine case to an ATF task force partner, that detective's department now faces a civil fine equivalent to an officer's annual salary. Critics call the figure intimidation. Supporters reply that without consequences. Sanctuary is a bumper sticker, not policy. Regardless, SAPA became the first modern law to penalize cooperation with federal gun enforcement, rather than politely request that it cease. The Justice Department under President Biden moved quickly, suing Missouri for violating the Supremacy Clause by nullifying federal statutes it dislikes. In March 2023, U.S. District Judge Brian Wimes agreed with Washington, branding the act invalid, null, void, and of no effect, and stressing that local officers remained free to work with federal partners without fear of SAPA's fines. He acknowledged that a state may decline to lend resources to a federal task force, but concluded the Missouri law crossed the line when it punished officials who chose to help. To countless Missourians, the order read less like a technical ruling and more like a judicial rebuke of their right to shape public safety priorities. The Attorney General filed an immediate appeal and, fearing agencies would reopen cooperation before the higher courts spoke, asked the Eighth Circuit for an emergency stay to freeze Judge Wimes's injunction. The Eighth Circuit declined to grant that stay. A three-judge panel observed that a state may withhold manpower if it wishes, yet reasoned that SAPA went further by declaring federal gun laws unenforceable inside Missouri. That distinction, resource allocation versus outright nullification, framed the oral arguments. On August 26, 2024, the panel affirmed the lower court and struck SAPA down in toto, deploying language that surprised even some opponents. The judges said the statute's structure might be acceptable, but its fatal flaw was the legislature's openly stated belief that certain federal gun restrictions violate the Second Amendment. In other words, Jefferson City's plan to withhold assistance could stand if rooted in budgetary or policy concerns, Because lawmakers cited constitutional fidelity, the court declared the whole scheme unlawful. For pro-Second Amendment observers, the message was unsettling. Professing loyalty to the Bill of Rights can itself be grounds for judicial invalidation. With its sanctuary project stillborn, Missouri took the fight to the only forum left. On January 23, 2025, the state filed a petition for certiorari, now docketed as 24-796, asking the Supreme Court to answer 3 questions. First, may federal courts condemn a state law purely because they dislike the legislature's reasoning? Second, does the Constitution forbid states from exercising 10th Amendment authority when that exercise rests on doubts about federal statutes? Third, can a state official be sued under the 1908 Ex parte Young Doctrine simply for obeying a state law rather than enforcing it? Missouri's brief argued no appellate decision in American history had punished a state for the motive behind its resource choices and accused the Eighth Circuit of inventing a doctrine that relegates Second Amendment concerns to second-class status. The petition also warned that treating passive obedience as enforcement would expose thousands of frontline officers to litigation any time they simply refuse to act, knowing the cert process can drag on for months. Missouri simultaneously sought an emergency stay that would resurrect SAPA while the justices considered the broader constitutional questions. On October 20, 2023, the Supreme Court denied that stay 8-1, with only Justice Clarence Thomas favoring temporary relief. The unsigned order was brief, but its impact was profound. SAPA remained enjoined, yet the denial did not prejudice the merits. Many read the silence from the court's other conservatives as evidence they wanted a more fully developed record before stepping in, exactly the pattern they followed with Texas's SB 8 abortion saga. For gun rights advocates, the move stung, but it also kept the path open for a full-blown merits review once the case ripened. Ordinarily, the Justice Department must respond to a cert petition within 30 days, yet the new administration, now led by President Trump, has asked for, and received, extension after extension. The public docket tells the story. The original February 26 deadline slid to March 28th, then to April 11th, then to April 25th, then to May 27th, and finally to June 10th, 2025. Each request cites the complexity of the issues and the need for interagency consultation, but insiders point to a delicate ethical minefield. The current Solicitor General, before joining the federal government, represented Missouri in defending SAPA and therefore has recused himself. Career deputies now draft the brief, aware that every adjective will be parsed for clues about the administration's gun rights stance. Too zealous a defense, and the White House looks captive to the firearms lobby, too feeble, and it risks alienating a base that helped carry the electoral map. As briefing inches forward, constitutional scholars note striking parallels between SAPA and Texas's SB 8, the 6-week abortion law that deputized private plaintiffs. In Whole Woman's Health v. Jackson, the Supreme Court ruled that state judges and clerks could not be enjoined because they merely processed lawsuits, though certain licensing officials with direct enforcement roles could be sued. SAPA borrows the same privatized enforcement model, except the forbidden conduct involves pistol braces and suppressor paperwork rather than medical procedures. The federal government wants the ex parte Young escape hatch to swing wide so it can enjoin sheriffs who refuse to share gun crime data. Missouri replies that Young applies only when an official enforces an allegedly unconstitutional statute, not when he stands aside. However the court harmonizes those doctrines, the reasoning will reverberate far beyond Jefferson City, because more than a dozen legislatures are already drafting SAPA-style bills. If the justices grant review and ultimately side with Missouri, the decision will reshape federal-state relations overnight. Legislatures from Florida to Idaho will gain a Supreme Court-approved roadmap for refusing to bankroll Washington's gun control experiments. Agencies like the ATF could still draft rules, yet they would need to pay full freight when state troopers decline to accompany raids aimed at stabilizing brace owners. Prosecutors considering whether to bring ghost gun cases could lean on the opinion to explain a polite no. Civil libertarians worried about red flag orders would applaud, not because they lust after high-capacity magazines, but because a revived 10th Amendment would once again tether federal power to the consent of each sovereign state. Meanwhile, private citizens in sanctuary jurisdictions would enjoy an extra layer of defense against edicts that mutate every 4 years, depending on who holds the Oval Office. The opposite scenario, a cert denial or an affirmance of the Eighth Circuit, would tilt the field toward gun control advocates. California or New Jersey could cite the precedent to compel cooperation from sheriffs now refusing to process pistol brace registrations. Legislatures flirting with SAPA clones might shelve those proposals, fearing legal fees stacked atop inevitable defeat. Federal prosecutors could threaten to withhold burn justice grants from departments that pull out of ATF task forces, secure in the knowledge that courts have blessed an expansive supremacy clause theory. Perhaps most unsettling, the motive scrutiny rationale would take root. If judges may discard a law because its sponsors proclaimed loyalty to the Second Amendment, nothing stops them from trashing tax reforms passed by legislators who admit they dislike social programs. Whatever path the court chooses, the ripple will wash over two other petitions still waiting in the wings: the Snope rifle ban from the Fourth Circuit and the Ocean State magazine cap out of the First. Both ask whether categorical bans on widely owned hardware comport with the Bruin test, which demands that modern firearm regulations fit firmly within the historical tradition of this nation. Observers expect the court to act on those petitions before the term ends, or, at the very least, to relist them repeatedly. Should the justices grant review while also taking Missouri's case? The 2025 to 2026 docket will evolve into a Second Amendment superterm, covering hardware bans, civil liability deterrence, and state autonomy in enforcement, all at once. That convergence would give the court a rare opportunity to clarify not only what arms are protected, but also how far a state may go when it believes Washington ignored the Bruin roadmap. Us patriots, defenders of the right to keep and bear arms. The strategic lesson is simple: stay engaged, demand crystal-clear statutory drafting, and insist that any sanctuary bill provides a legal defense mechanism for officers caught in the crossfire. The Eighth Circuit didn't object to Missouri's decision to allocate resources. It objected to the legislature's candid statement that certain federal statutes violate the Constitution. A future act that merely says, "State officials shall not enforce federal gun controls," while staying silent on legal theory, could dodge the panel's criticism, even if it achieves the same practical effect. Policymakers drafting such bills should also budget for litigation funds, so sheriffs and chiefs aren't left paying lawyers out of pocket. Transparency matters too. Departments that decline to share ballistics data should log the hours they save and the local cases they clear. Facts beat talking points when the press asks why officers sit out an ATF sweep. Gun owners who don't occupy elected office still play a crucial role. Monitor the court's orders list every Monday morning and share verified updates instead of rumor mill screenshots. The gun control lobby thrives on confusion. When would-be buyers fear that tomorrow's rule change might strand them with non-transferable rifles, they delay purchases and the culture contracts. As matters stand today, SAPA remains on ice, yet nothing stops counties from passing budget ordinances declaring that discretionary overtime will not subsidize federal weapon-specific raids. While those ordinances lack SAPA's civil penalties, they send a crystal-clear message about local priorities. County-level culture often foreshadows state-level law. If you live outside Missouri, attend your commission meetings and ask officials how much task force participation costs in fuel, insurance, and officer burnout. Dollars and cents arguments routinely sway fence-sitting taxpayers who don't speak the language of constitutional theory. June 10th draws near, and the Solicitor General's forthcoming brief will either escalate or de-escalate the confrontation. A document that concedes Judge Wimes may have gone too far could nudge the court toward a narrow middle ground, perhaps slicing off SAPA's civil penalty provision while blessing the resource withholding core. A brief that doubles down on the supremacy clause could inflame an already energized pro-Second Amendment electorate and galvanize more states to pursue sanctuary language no matter the litigation risks. Whatever the federal response, the court's docket, the Bruin framework, and the relentless innovation of state lawmakers guarantee that the conversation will not end in June. But that's going to do it for this video. So, do you think states should bankroll federal gun crackdowns, or should local deputies stand their constitutional ground? Drop your take below, hit like if you learned something, share this with friends who carry, smash subscribe, and ring that bell so you never miss an update in the fight to preserve the Second Amendment. Forever.